divorce and property rights. When a person married his mate, he may have officially claimed property or had money reserve funds or investments. His life partner likewise may have entered the marriage with property, money or potentially ventures. This is called separate property. Amid the marriage, he and his life partner in all likelihood got more property and money. Under most conditions, the property and money he acquired amid the marriage will be declared to be marital property. The marital property obtained amid the marriage is known as the marital estate. A person and his mate may reject certain property from the marital estate by going into a marital agreement, for example, a prenuptial or postnuptial agreement. Without such an agreement, there is a presumption that property gained amid the marriage is marital property. Marital property incorporates real property person and his life partner purchased amid the marriage, aside from any commitments of his separate property he may have made to such property, such as paying part or the majority of the initial installment of separate property funds. Personal property, similar to autos, watercrafts, planes, furniture, and work of art he and his companion purchased amid the marriage. Cash, securities, financial balances, and retirement accounts gained amid the marriage. Advanced educational degrees and licenses to take part in particular organizations obtained amid the marriage. Separate property incorporates real property he got or possessed preceding the marriage. Personal property he got or possessed before the marriage. Property he got by inheritance or gift from somebody other than his mate amid the marriage. Compensation he gotten for individual wounds amid the marriage not identified with loss of wages or gaining capacity amid the marriage. Property he procured in return for his separate property amid the marriage. Any increment in the estimation of his separate property, but to the degree that the expansion is because of commitments or endeavors of his companion or self amid the marriage. Property depicted as separate property in a written agreement amongst him and his life partner. When a person or his life partner records for a legal divorce or separation, he can concur on the division of marital property and separate property. In the event that he can't concur, the court will choose, after trial, which property is separate property and which property is marital property. The court will likewise choose what might be a reasonable and impartial, yet not really equivalent, division of the marital property. Unless a person has blended or mixed together his separate property with marital property, his separate property remains his property after the divorce, thus does his life partner's separate property. The court will affirm that his separate property has a place with him and his life partner's separate property has a place with his mate. Be that as it may, in the event that a person blends or mixes his separate property with marital property, the court may consider part or the greater part of his separate property to be marital property, and separation it up with his life partner. This control does not more often than not have any significant bearing to real estate, especially the marital home, where a separate property commitment to the buyer will typically remain his separate property. He will have the capacity to recover his separate property commitment after the marital house is sold. Examples 1. A person acquires stock and stores it into a mutually possessed venture account that both he and his companion attempted to develop. A court may consider a piece of the expansion in his separate inheritance to be marital property, and it will be isolated up in that capacity. 2. A person brought an important antique chair into the marriage, yet it was in disrepair. He urged his life partner to work on the chair and get it back fit as a fiddle available to be purchased. His life partner does as such, and at the time of the divorce, the chair has incredibly expanded in esteem. A court may consider the expanded estimation of the chair to be marital property because of his life partner's immediate commitment to expanding its esteem. 3. Person has a bank account from before the marriage in his name and after the marriage, he includes his companion's name. By including their name, there is presently an assumption of an endowment of one a large portion of the estimation of the record. Once the court decides the marital pot or the marital estate, it will start the procedure of esteeming and afterward partitioning the marital property. New York courts must partition the marital property equitably. That implies reasonably, considering the conditions of the case and of the gatherings included, however it doesn't really signify equally. In New York, the property is not naturally isolated down the middle and circulated similarly to every mate. Rather, the court considers 13 particular factors deciding the equitable distribution of property. 1. The salary and property of every life partner at the time of the marriage, and at the time of the divorce. 2. The length of the marriage and the age and strength of both life partners. 3. If there are minor children included, the need of the life partner who has guardianship of the kids to live in the marital habitation and to utilize or possess its household contents. 4. The loss of inheritance and benefits privileges of every mate as a result of the divorce. 5. The loss of health insurance benefits of every companion as a result of the separation. 6. Any honor of support or upkeep the court will make. 7. Whether one mate made commitments to marital property that the companion does not have title to. For instance, where one life partner helps the other mate increment their capacity to win more cash by getting a degree or certification. 8. The fluid or non-fluid character of all marital property. 9. The probable future money-related conditions of each party. 10. The inconceivability or trouble of deciding the estimation of specific resources, similar to interests in a business, and whether one life partner ought to be granted the business so it can keep running without obstruction by the other mate. 11. The tax consequences to each gathering. 12. Whether either companion has wasted or spent any of the marital property while the divorce was progressing. 13. Whether either life partner exchanged or discarded marital property at not as much as market esteem, realizing that the divorce would happen. Indeed, even in the wake of considering these elements, the court may consider whatever another element it observes to be reasonable in landing at an impartial dispersion of the marital property. Likewise, certain sorts of property can't be separated. All things considered, the court may make a distributive award. A distributive award is a monetarily related installment by one life partner to the next either in a single amount or paid after some time. Example: a person's life partner earned a medical degree amid the marriage and now maintains a medical business. Both the degree and practice might be viewed as marital property due to his commitment to his life partner's capacity to earn more cash as a specialist. The court won't close the business, yet may arrange that his life partner pays him a fixed amount for his commitment to the medical degree and to the business every year over a time of quite a while. 4 free samples of probates, inherited, foreclosures, absentees landlord, vacant, code violations, evictions list. Visit www.realsupermarket.com.